Bob raised the issue about the effectiveness of executive orders, and it's a very legitimate one, and one over that another time might have been taking up a lot more space in a way. But the starting point for this topic of the feds interfering with local environmental efforts really actually goes back to another executive order that Trump issued in either March or April. I don't remember which it was. And in it, he was directing especially the Department of Justice to go after several things. One was efforts either by law or litigation in states to find GHG emitters liable for the potential damages and the costs of, uh, that were rising from climate change, and some of that also has been signed in with foreseeable results, and it's been and one of the problems with that approach, which has been there, but that is used in an effort to minimize it by the federal government, because it has gone after a couple of places around that to try to block their laws on the subject. I think the most prominent one is probably in Hawaii. Um, Part of the argument is well, okay, so can you really show one particular industry or one particular polluter, even if it's Exxon or a big coal company, that they have a measurable effect on the outcome, on the harm that is inflicted on someone else. So that has been one of the avenues that they've used to try to block efforts at the state level to and lawsuits at the state level brought even by the states to try to get uh, uh, some recompense from the major GHG emitters for the harm that follows. And in the case of Hawaii, it actually started out, I think, with a fire down there that was very unseasonal. There was no precedent for. It had to do with the change in climate. Another related area that they've been looking at are the so-called Superfund laws, and there are two of those, one in New York and one in Vermont, that effectively create, hold again the industry responsible for harm suffered in the state. And it follows a little bit of the Superfund model, which I can't tell you I'm an expert about, but there would be requirement for them to kick into a fund which would be used for remediation, for resilience activities, and so on. That's another one of the items that were targeted in the original executive order, and in fact have been targets more recently. There is litigation going on around that. Uh, in addition to that, they've looked at and this is very broad sweep, but it's looking at the whole country. They've been looking at what they consider burdensome programs and regulatory regimes that suggesting that the Department of Justice go after those partially on grounds that they're unreasonably interfering with interstate commerce. And you were asking, Bob, before a little bit about the AI issue. I don't know because I haven't read that or what they've done exactly, but certainly an argument is going to be, well, this is an interstate commerce. Most of the activities impacted substantially, and therefore it's an area for potential federal preemption, and we need to shut down anything that interferes with our larger economic program. They also identify permitting delays in that area. I don't know of any around here that have been subject to new attack as opposed to maybe older ones. And they also looked at cap and trade programs. They did, I don't know whether you could call Reggie a cap and trade program, but in a sense it's similar. And I think we can expect that the DOJ is going to go after it. There are other ways in which the federal government is, in my view, affected local processes. Certainly, offshore wind, which has historically been certain aspects of it have been regulated at the state level or funded at the state level. Other aspects have been done federally. In theory, there's a bright line out 3 miles beyond our shores where federal law is supreme. But in fact, most of these most projects, are both inside and outside, and have been subject to joint regulation. The Trump administration's tried to shut some down. In one case, the court said no, it's too late. The argument there was because it was significantly advanced. And we have here in Virginia, for whatever reason, they did not attempt to shut down the offshore wind project here. And I'm not quite sure why that is, but I suspect it's again sunk costs, and they were probably told by the Youngkin administration, if you leave these facilities in place, all that's going to happen is that you're going to increase ratepayers' obligations, and they'll receive no benefit from it. So I think that's probably why locally they have not gone after the offshore wind project here in Virginia.
Although Youngkin was not nearly as supportive as he could have been.
No, but I can see that behind the scenes, the economic argument might have been, you're really going to create a problem for us because this is so close to completion, which it is.
Is there any threat, Bill, to Reggie itself from the federal
government? Well, there
may
well be. I mean, they've gone after the cap and trade programs, and their argument has been, this is this is something that should be under the Commerce Clause of the federal Constitution, and states should not be able to regulate this or engage in a complicated market forming as the cap and trade programs do, and arguably Reggie does the same. So I don't think that they're high on the list of things they want to go after, but I can certainly see that their argument would be along those lines. If they're going to make it, and the problem here is they're likely to get some very favorable court decisions that will allow them to do things and prohibit states from doing things that would not have been possible before.
And you're referring specifically to the Supreme Court's.
Yes.
Yeah.
At the Supreme Court level, and the big threat, of course, at the Supreme Court level is that the endangerment finding, which was the whole basis for regulating greenhouse gases, we're going back to the early 2000s here, is the EPA has already said that they're going to revoke it. Their argument is not that there's not a danger, but that the danger is exaggerated.
I mean, there's already data showing pretty substantial impacts on crop yields.
Peter,
I'm just saying, wouldn't that be a very effective counter argument?
Yes, it would be an effective counter argument in a better world, but and I don't want to. I'm probably not, without some preparation, I couldn't even go through all the twists and turns around this endangerment finding and how the court could deal with it. and how it will apply it. Because first, I mean, originally it dealt with automobiles and well, with other transportation. Uh, but there was then in place either a statutory provision or regulation, which sort of gave the EPA authority to expand its coverage of greenhouse gases uh, into the power sector. Um, as you probably know, there was not too long ago that this Supreme Court said, wait, this is such a sweet, if you're about the power plan that was proposed during Democratic administrations, that you can't do this, even though it may look like even the EPA said with the extending the Clean Air Act provisions that were in 1970. You can't do this because it's too big a thing. And for something that big, you need to get Congress to approve uh, an approach. They've already said that about the Clean Power Plan that was proposed before. So the speculation is that they will probably say something like that about as we go forward, and if the EPA comes up with a new non-endangerment finding, that you know it will give uh, that you're not going to get a lot of help. One writer has noted that if they really wipe it away so that the EPA is no longer regulating this, uh, that actually there might be room for what are called public nuisance tort suits that are precluded because or have been precluded on the grounds that it's an area that's regulated, so that common law tort remedies can no longer don't have a place. But if you eliminate the regulation, maybe you can come in and you know on a whole different legal theory. All of this does us very little good because we're talking years of wrangling and litigation around it. But the point, I think, the point here though is that they're moving in strategic ways to make it more and more difficult for states to operate separately, and this expansive executive order around AI is another example of that too. It's
I
we'll
mean, I
see
know
what
what you're going to say, but what does
happens.
the Federalist Society say about all of this?
Unitary executive.
Oh, how does that square? All right.
So,
Thanks a lot, Bill. Do you have anything else?
no, but I'm happy to try to answer any questions you all may have. And there is a whole lot more, but I mean, you can almost do a law school course on this subject. But
I mean, I liked your point about, and I take it, you know, I understand that it would be a very lengthy process, but I'm getting close to finishing a book on the court battles around hog farms in eastern North Carolina, and it's kind of the same principle, right? It's like you're infringing on someone else's enjoyment of their property and of their
on their
life.
property, exactly. You know, and you know, Peter, what you're saying, it goes back. I mean, this notion of common law tort it's been one of the oldest principles in law, going back to Roman times. The you know in our Western world, that yes, you could use your property, but if it harms others, you're subject to, you know, then you got to rein it in, especially if you know it's going to harm others. And especially, and here we can get off on another tangent, if you hide from the world what you know.
Yeah.
And that was the really reason why, you know, 2 years ago or a year and a half ago, there was a lengthy article in the Harvard Environmental Law Review about how people should be especially in the oil and gas industry, where they did a whole lot of lobbying and distortion, why they should be held criminally liable for homicide. So we've come a long way since then with the arrival of Mr. Trump. But it's just, but you're absolutely right. It is. It's a fundamental
Yeah, I
piece
mean, it,
of of the legal system. What's a legal system for except to protect people from others?
Well, Bill, wasn't there a lawsuit around Smithfield because the swill and the sewage from around the places down there where they were slaughtering, and processing hogs. I think the water was polluting the state of Virginia waters, and I think they had to rein it in. Correct?
I believe that's the case, and Peter may know more about it since he's expert on the hog industry, which I can't say.
that's me. Yep.
But yes, and again, a lot of these were under clean water was regulation which exists both at the state and federal level, or existed at least in the not too distant past. And you're absolutely right, Madison. I do think there was something there. I don't remember the details of the basis for the suit, but
it's been 20 years or more, probably.
Yeah, they were stopped. So,
well, I mean, one of the things that's a little disturbing to me is, obviously the economic interests of, certain industries are at play here, but
yeah.
It's also a case of a philosophical, just demolition led by basically Project 2025 types like Russell Vogt, right? Basically, that any environmental regulation from the 20th century essentially is
inherently suspect.
Is communism.
Communism. There we go. There's even been some talk, and here this one will make everybody really happy. I don't think it doesn't exist yet, but there's been talk of exempting the fossil fuel industry from civil liability to anyone, much as gun manufacturers were. There was a statute passed not too long ago exempting gun manufacturers from liability for harms done by their guns.
Yeah, but
so they're going to try to frame something like that. There are people in Congress today that are trying to frame something like that.
There's not a constitutional. It's not in the Bill of Rights to burn the world down.
It's not in your Bill of Rights. It's in their Bill of Rights.
Well, there's no amendment like the Second Amendment, is what I'm saying.